welcome to Faith and Facts. Today I'm so excited. We have Keith Codron here from Law Offices of Keith Codron, and he is an amazing estate and trust planner.
I'm a solo practitioner in Irvine, and I'm certified by the State Bar of California as a specialist in estate planning, probate, and trust law. I've been practicing in Irvine for 42 years, um, and I'm going to keep practicing until I get it right, of course. But I do a lot of drafting of trust and will documents and powers of attorney and other testamentary documents. Testamentary means someone's going to die. And I also do more advanced documents, such as charitable trusts and irrevocable life insurance trusts. I also do offshore and domestic asset protection, um, because a revocable living trust will not protect you from your creditors. But properly structured, certain irrevocable trusts, usually coupled with limited liability companies or family partnerships, can provide some protection from creditors. If it's set up in advance, that's the key to offshore or to any asset protection. Set it up before you need it.
I love that.
Not when the jury's coming in with a verdict against you tomorrow. Besides the estate planning, I also do trust and estate administration as after one spouse dies and then the second spouse dies or becomes incapacitated, and a revocable trust then becomes irrevocable. There's a lot of work to be done in administering a trust, even if it's not going through the court process like a will is. And then also I do trust and estate litigation when there are disputes. And there are very many situations in which disputes can arise between siblings and other claimants. So I do I call it the three legs of the stool: planning, the administration, and the litigation
Got it.
when it's necessary.
Keith, there's so much to unpack on everything you do. And a lot of it, I myself, being a professional in the real estate industry, have heard a lot about, but there's other terms that are still very confusing for me. So if they're confusing for me and I hear about it with my clients so much, I'm sure it's confusing for a lot of our viewers, a lot of people out there. So today I want our talk to be a little bit, I want you to talk to me like I'm a freshman in high school, or I want you to talk to me as a much older person that's just coming into money and never actually had any money conversations with my family. And the reason why I want to do that is I just want to kind of simplify or bring people into the conversation, bring others on the table to sit with us and be able to understand what's happening and prepare. Because I know your industry, what you do and you specialize in, am I correct? It's a lot of basically preparation for death, for taxes, for what happened.
Death and incapacity.
Yes, yes.
So I also handle conservatorships when the need arises.
Got it. And
So
we have a lot of that right now. We have the baby boomers coming out, right? I mean, even in real estate, we're seeing a lot of the homes are going to be homes that people have held for 20, 30 years.
yes,
And so you're going to be such a big hand in that on what they do and how it's all distributed and what happens after they pass on.
and speaking of homes, let me just jump quickly to Proposition 19, which we
Yes,
had a
thank
few
you.
years ago.
I'm gonna check that off my
Okay.
list, talking about
Um,
property. Yeah,
if-
start by telling us what it is in layman's terms first.
okay. Uh, if you have owned a home here in Orange County, for example, for decades,
Mm.
um, and Proposition 13 came into the law back in 1978. So you may be paying a very low, you may be paying property taxes based on a very low assessed value compared to the market value of that property.
Mhm.
However, when you pass, your children, because of Prop 19 that was enacted several years ago, your children are going to have a rude awakening as terms of reassessment.
Mhm.
And that reassessment can be 10 times, again, depending on what
Yeah.
you bought the property for. But if you bought it 30, 40 years ago and you're, let's say, in Newport Beach, when,
Now the property could be worth millions,
could be
but
wor-
still being assessed off 300,000-400,000.
exactly.
Yeah.
But that ends when you pass away. Now, there is a limited exemption. It used to be an unlimited uh, parent to child transfer exclusion before Prop 19, but now it's limited to just $1 million, and that's only if a child lives there within 12 months of your death. So in most cases, the children are not living in the home of their deceased parent and have no intention of moving anywhere. So what happens is that the property will need to be sold unless the children are willing to pay a much higher property tax than what their parents were paying. And I mean, this is true really throughout the state, but is especially important here in Orange County, where prices have just gone skyrocketed.
Well, let me just pause you there. So, Property 19, I actually am a Proposition 19. I'm actually a certified probate real estate agent. Doesn't make me any better, but it does say that I've studied a little bit more about this, and I've handled a few probates. Proposition 19 is supposed to protect and give them tax breaks when you pass away. Or is Proposition 19 when they get
Proposition
the same tax rate moving to a different
Right.
property?
Proposition 19, and this is the way it was marketed
Mhm.
to the public, allows people over 55 to
Move.
port,
Yeah.
P-O-R-T, port or move their uh,
Their
tax base
rate.
to another property, if it's their residence, from one residence to another, and in any county in California. Under the old regime, there are only 5 counties where you could port your.
This also extends to wildlife, fire disasters, people that have gone through just
Yes, and Prop 19
yeah.
came. It was marketed shortly after a lot of the wildfires
Yes,
started.
yes, yes.
So it's true that for older people, Prop 19 has a benefit, but what wasn't explained, and I'm not blaming the realtors or anything like that.
Yeah.
Uh,
You can blame us a little
you
bit.
know, it just although it's not explained in the TV commercials when Prop 19 was being sold to the public, is that that when the person dies, who has an appreciated property, whether it's home or commercial or industrial, um, that there's no more parent to child transfer exclusion.
Oh, interesting. So even as the I know that
The primary residence has a very limited one, only up to $1 million,
right. But
and it's
any
only if a child of that deceased homeowner w- moves into that home
yeah. Or lived with them.
or lives
Yes,
with it.
yes, yes, yes.
Yes. So
Okay.
the-
So just to get that clear, you do have some kind of a tax break up to $1 million on the primary home if the beneficiary lived in the home upon the passing.
yes.
Yeah,
If
yes. Now, it doesn't extend to any investment property. So let's say my father, knocking on wood, is ready to pass his on. I don't live in his home. Of course, my stepmom was there. She's going to take it over. But if she wasn't a part of the picture, I would have to pay taxes on that home
yes, when you inherit it
based on the market's assessment at the time of death.
at the time of death, and that's important. Not when the probate administration is over or the trust administration. It's retroactive to the date of death.
Got it. Got it.
And if a child moves who was not living there at the time of the parent's death, moves in and then moves out.
Yeah.
Okay. If they move in within 12 months, they can claim that exemption.
Yeah.
First million.
Up to $1 million.
And then once they move out, all bets are off. It's going to be reassessed again.
Oh, interesting.
Yes.
Interesting.
Because the
you gotta-
assessor doesn't want any
Yeah.
gain.
You have to stay in there until
At least one child.
yes, until it's completely done, until it's sold or the assets
That's true.
distributed or all of that. Okay, got it.
So what does this
Yeah.
do? It encourages sales.
Yeah, that's the way that they were kind of like shaking and moving the market. Because a lot of people are staying in their homes longer because of their tax rates and because of the values. They just skyrocket.
Right.
But a lot of people don't understand when you pass, your child's going to be paying a lot of taxes
Unless they sell that.
unless they sell it
And most children
and move it into another.
do not reside with their elderly parent.
Mhm.
They will opt, especially if you have 4 or 5 siblings,
Yeah.
which is often the case
Yeah.
with what I handle.
Is there any way
They-
around
they want
so much
yeah.
taxes that Like, is there any way to protect them to extend it to another home or maybe even increase that limit? Is there anything that we can do,
Well,
or our hands just tied?
with property taxes, when someone dies, this is California real
Yeah.
property only.
Yeah.
The answer really is no.
Got
It's,
it. Yeah.
and by the way, that $1 million exemption, that's only for, besides the other conditions being met, that's only for the primary residence.
That's right. Yes. And a lot of
It's not for a secondary, right? And it certainly is not for rental.
here in Orange County, I mean, they bought so long ago that they don't own just one home. They own at least 2, 3 other homes.
Right.
I mean, quite a few of my clients in Irvine purchased homes in the 80s, 70s, and 80s for 200 grand. And now they're worth over $1 million. So they've extended to Riverside. They bought another one in another part of Orange County.
And it's all going to
There's
be,
just no way around that. Then.
there's no way around it.
Got it. So their beneficiaries are basically just looking at being hit hard.
Yeah. If they own, if they own the home until their death.
Yeah.
Yeah.
Yeah. Yeah. Now, that brings me to another thing we talked about, charitable
Remainder
remainders,
trust. Right.
remainder trust. And I think that might be not a loophole, but a way around so much of that. Could you tell us if it is?
Well, sure. Well, the charitable remainder trust is, it will allow someone to avoid capital gains tax on the appreciation that they've experienced, in whether it's rental property or their own home, raw land, doesn't
Yeah.
matter. By gifting while they're alive, of course.
Yeah.
It's not bequeathing, but gifting title to that appreciated real property into the charitable remainder trust, which is a tax exempt entity and will not pay that capital gains tax when it then sells the property.
Okay, I want to just briefly stop there because I want to remember that I also want my freshman me to understand this. Capital gains is the amount of are taxes that are based off the amount you paid and the amount you sell it for.
Right.
So if
Well,
you bought a property for 100 grand and you sell it for 500 grand, capital gains will be based, they'll tax you on that $400,000 difference.
However, if you have made capital improvements,
Which are
Which-
like changes to the home.
well, let's say you put on a new roof.
Yes, yes.
Well, you put in a new HVAC system.
Yes, yes.
Not painting the fence.
Yeah,
But
yeah.
but things which add more than a year of what we call useful life.
Yeah.
Sorry for the lingo.
Yeah.
Yeah,
For
you can-
talking about debt.
and if you keep your receipts, you can add that to your cost basis.
Great, great.
Plus, with a primary residence, and this only applies to primary residence, on a sale of a home, the spouses each get 250,000, so 500,000 total
That's 200
exclusion from the
Yeah.
gain.
Yeah.
That does not apply to rental properties or any other. That's only
That's
to the resident.
really the primary residence is where you can get the most brace. Now, a single person owning a property will still get that 250,000.
Right.
But if you're married, then you can combine it together. So let's say the property is 100 grand, you sell it for 500, the capital gains is the 400 grand right there, but you
But
can get,
if it's covered by the exclusion,
yeah,
like
you don't pay taxes.
yeah, but a lot, but the people who would come to me for charitable remainder trust don't have a $400,000.
No,
gain.
no.
That's
That's
a $4
just trying.
million gain.
Well, I wanted to break the
Right.
definition down into layman's terms
Right.
because I know we try to expect we want to know that everybody knows what we're talking about because and I don't want anybody to be lost, and it's so easy to get lost because there's so much to what
In
you
its
do.
simplest form,
Yeah,
capital gains is the tax that is paid
yeah,
on the difference between the amount that you receive on a sale
got it. There you go.
versus what you paid for.
Perfect. And now tell us about
And that's not just
Yeah.
for real estate, that's for stock
yeah.
or for any other capital asset.
Yep. I know I had to pay that on crypto sales, so, but I didn't pay. Yeah, I deferred my taxes on that. So,
And you now have to disclose on your tax form
yeah.
if you have had any transactions in crypto,
Yes.
because that's treated as a commodity.
That's a separate. We're going to go into that. That's a great topic we're going to put on the back burner because I love crypto. I made a lot of money off crypto, and I know it's like kind of one of those ticklish topics, if I could say. People are curious about it, so we'll put that on the back burner for maybe next time. But
So we'll talk about blockchains and mining and other topics.
wow, look at you! I actually have a few
I can just talk the talk with that stuff.
Well, there you go. Blow a little smoke out that ass, Keith. But okay, so
So why have
They-
I have a revocable living trust, for
Yeah.
example?
there you go.
Because while it won't protect you from your creditors, It will protect you from, or really your heirs and descendants, from probate court.
Tell us.
Okay, when probate, well, probate literally means to prove. And what's being proved? It's a will. A will has to go through probate, and then an executor has to be appointed. The court oversees everything, and the on the first $1 million of probatable assets, the attorney is entitled to a fee by statute of 23,000, and the executor is entitled to 23,000. That's on the first million. The next 9 million is 1% going to the attorney and to the executor. So it can become very expensive. In
Is
addition,
that on top of the 23 grand to begin
yeah,
with?
yes, over and above the
Great.
23 and
So
the
if it's
first one.
2 grand, if it's 2 million,
So
it's
so
25.
so we had
plus 20.
another 10,000 per.
10,000, yeah.
Right. So 30,
Got him. That's
33,000 for one, 33,000 for the other. Um, but there are also court costs in addition to the fees. So and you have to get permission from the judge to do a lot of things, especially when it comes to the sale of real
yeah,
property.
yeah. I mean, you
Uh,
have to get their permission on what you're going to sell it for,
right.
who the buyers
You
are.
have to get bids,
You got to get bids. You can still even get outbid at court.
and it's a public document.
That's right. Yes.
Whereas a trust is
So probate is just way more. You don't have too much power as the heirs on that one.
yeah, well, it's restricted
Mm-hmm.
compared to a revocable trust, which still lets you change the terms anytime you want. Um, and revocable really means you can pull the assets out of the trust.
Yeah.
But a revocable trust is also a fully modifiable trust, meaning you could change the terms and conditions. To get creditor protection, you need a irrevocable trust, which we can talk about maybe in the next segment.
Yeah.
Um, but even a will, which goes through probate, is better than having nothing, because then your estate will still go through the probate court.
But
And
they'll know more about who's going.
not just that, but the state of California will have an estate plan for you, and you probably won't like it.
Well, let's stop for a second here because we're hearing irrevocable trust. We're hearing revocable trust. Let's start with obviously the difference between what I'm understanding from you. The difference between wills and trust is wills kind of leave it open and ended a little bit, or less secure, so the courts still have their hand in what happens.
Yeah, a will has to be administered in the court system.
Got it. Okay.
But if you don't have any will,
yes.
you're going into the court system
Yeah.
anyway
So at least
with
there's
nothing.
something. Yes.
So a will is, in terms of comparative advantage, the worst thing is to die with
Nothing.
n-
Now, can I sit right here and on this piece of paper with my questions for you, write my will out? Will that hold in court if I said, you know what?
in California, a holographic will, which is what that is,
Mhm.
as long as you sign it and date it, and if it's all your own handwriting, and it was not the product of what we call undue influence
Yeah.
by someone else, then it will be accepted. The thing is, it's just harder. If you write your own will, chances are you're going to leave important things out, such as no bond necessary. If a do-it-yourselfer writes their own will, they're probably not going to think about putting in a provision to do away with the bond requirement.
Oh, yeah.
So what does that mean? Let's say you wrote your own will and you had a $5 million estate, and the person who you want to be appointed as executor then has to go get a bond, and that may cost many, many thousands of dollars based on the size of your estate. And if they have bad credit, it's even more money.
A bond is just to make sure they come back and they're not doing anything they shouldn't be
A
doing.
bond is to make sure that
Like if there's cash or jewelry in the house, they
Right.
can't go sell it.
if they pilfer uh, anything from the estate,
Got it.
anything that's not accounted for,
Yes,
and you have
yes,
to do
yes.
accounting.
Because it takes a while. So someone dies, still takes time to go to the court.
It's
Still
an
takes time to finish
18 to
it.
24-month process,
18 to 24
and
months.
that's assuming no one.
Yeah.
Could,
I mean, I know with my probates, I mean, it's taken, I think, well, COVID hit, took 2 years, but it could be done in as fast as 8 to 9 months, but nothing really sooner than that.
and that's with everyone on the same
Yeah.
page.
Yeah.
If even one heir or named beneficiary says,
You still need to do
I don't.
public notice. So if anyone comes out of the woodworks and goes, "Hey, I actually am related to that person,"
You don't need to do public notice with a trust.
that's where I wanted to go into.
But if the
This-
trust is
yeah.
going to be, if the trust is contested, and so the trust then goes before a court,
Yeah.
then you do need to give notice to all of the the trust makers,
Yes.
heirs and beneficiaries.
Yes.
Not
So
split, but and any claimants that the trustee knows of.
great. Okay, that's with the trust.
And heaven help the trustee who distributes out the trust before all the claims are paid, and that includes IRS and Franchise Tax Board.
Yeah.
Because then the trustee is personally liable.
Right. Yes, it is. So that's actually something I experienced last year where I sold a property for a client. There was about 4 or 5 beneficiaries. One of them was a trustee. Thankfully, there was no co-trustee because you could actually put more than one person in charge of your trust.
And that's a bad idea.
And
One of the no-nos that I instruct clients is don't name 2 or 3 of your children as co-trustees. You think that that'll help them get along, or one will watch the other, checks and balances. All it does is create problems logistically and within the family, emotional. You name one of your, if you don't want to go with a private professional fiduciary or trust company, which I strongly advise you do if it's a larger estate, then name just one child, and you can name other children as successors if
Yeah.
the first child is no longer is unable or unwilling to serve, whether by death, incapacity, move to Timbuktu, whatever it is.
I
But
want
don't name 2 or 3 children at a time as co-trustees. You're inviting litigation.
got it. And that was something we're going into litigation. Now, let's say, well, let me back up a real quick. How many kinds of trusts are there? Just
Oh,
name them just for a second. Are there
dynasty trust. Yeah, that's
Oh,
multi-generational
okay.
trust.
what are the most common?
Spousal lifetime access trust.
Ooh.
There's irrevocable life insurance trust.
Okay,
These
okay.
grantor retain. I could
Okay.
go on.
Well, I didn't know.
Oh,
there
we're
was
running out of time.
trust. Okay, okay. We're not going to go into that, but
Most
thought- yeah.
people who do just the basic estate plan,
yeah,
which again is a lot better than just having a will,
yeah, yeah.
do a revocable living trust, wills, what we call pour over wills, a will that says I leave everything to the trust. And the reason why we have wills with a trust, so that if something doesn't get funded into the trust, those wills will catch it.
Got it.
But they still have to be probate
Yes, yes.
for anything that's.
Well, at least there's still some kind of protection.
And then we do a
Yeah.
durable power of attorney,
Yeah.
very important. And again, don't name 2 children as your agent under the power of attorney. Name one and then a successor
Power of attorney and successor are basically just people that are in charge of what's going to happen
while you're alive.
while you're alive.
If you
And
become-
power of attorney is while you're alive.
Definitely, because the power.
Successor is when you're dead.
A power of attorney expires when you do.
Mm.
The word durable in durable power of attorney means that if you become incapacitated after you've signed that power of attorney, it stays in force. It endures
Great.
past the point of your incapacity. But when you die, the power of attorney is done. But it's a very powerful document, so you will want to be very careful who you name to be your agent. And it comes in 2 flavors: the immediately enforced or the springing. And the difference is, if it's a springing, the document will say this will become in force when 2 physicians have certified that I can no longer handle my own assets,
Yeah.
that I'm mentally incompetent or worse than
Yeah.
And the other is one that becomes immediately effective.
Got it.
The other document in the basic estate planning package is the Advanced Healthcare Directive. You go into an ER or anything in a hospital, one of the first things that the nurse at the station will ask you for, do you have a directive?
Yeah.
They'll just call it a directive.
Are you in charge of basically making their decisions on their health?
Who is, right,
Yeah.
when you're on the
Yeah.
the operating
Yeah.
table, a bit indisposed, shall we say?
A little busy, trying to fight for your life?
Yes. They want to know, okay, who can consent to medical treatments on your behalf?
Got it.
Who can authorize the do not resuscitate?
God, that's got to be rough. I mean, you got to want you back.
Disposition of your remains,
Yeah.
if that's your final stay. That's very important. That's all covered in an Advanced Health Care Directive.
Advanced.
And with that, I do a HIPAA. HIPAA has to do with medical privacy.
Yeah,
I do a HIPAA release document. So along with the trust, there's a a package
Yes.
of
There's
documents.
little things you could insert there, huh?
Yeah, and it's important that the whole package be done.
I understand. I got
Okay.
that. I wanted to ask you real
The
quick.
other trust that I was talking
Yeah.
about before, with all the acronyms, the slats, drafts,
Yeah.
eyelids, the dynasty trust, those are all
Like
advanced, and the CRT, the charitable
Yeah.
trust, those are advanced planning, as are any type of asset protection trust, offshore or domestic.
I'm curious about the first. I want you to just briefly educate me on the charitable trust while you're alive, how it protects you from taxes, because I think that will really benefit people with multiple assets that want to kind of alleviate their taxes
Well,
while they're alive.
well, with a charitable trust, you avoid that imposition of capital gains when you gift it to the
Mhm.
charitable trust, because the CRT is a special section of the tax code 664 which exempts charitable trust from tax. You also get a income tax deduction. So you avoid capital gains tax, you get an income tax deduction, which is based on the payout, which I'll talk about in a second, and your age or the term of years of the trust. And then it's out of your out of probate, and
Yeah.
it's out of your taxable estate too. So the way it's usually set up, once the let's
Give
say
me an example of
yes,
one that would
like
be used. That's great. Yeah.
a Newport Beach highly appreciated rental property.
Mm-hmm.
Maybe that was purchased in the 60s for 300,000, excuse me,
Mm-hmm.
is now worth 5 million. Um, the before the listing agreement could be signed, but that's all. There can't be any purchase agreement
Without.
before
Yes.
the CRT is put in place.
Got it.
Otherwise, all bets are off tax wise.
Mm.
So, if uh, a client of yours has found a buyer, but before there's anything in writing, other than
Choose a
just
charity. Yeah.
no anything in writing as far as between seller and buyer,
Yeah. 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 Yeah.
cannot have that
Yes.
purchase agreement
Yeah.
in full. That's
So you're an owner. You own in Newport Beach.
yeah,
You're going to sell this
and you know that
property.
you're going to be
Yeah.
selling this
Yeah.
property. First thing you want to do is set up the charitable maker trust with an experienced lawyer, um, and then you transfer title
Mhm.
into the CRT. It's better if you have a trust company be the, you can be your own trustee of a charitable trust. I don't advise it because it's complicated,
Mhm.
the administration of it. Um, Once that CRT has title, the trustee can sell that, no tax then,
Yeah.
sell it on the later, and the proceeds then can be used to pay an annuity basically to the client for life or for a term of years up to 20.
So if I'm a Newport, if I am that owner, if I'm that person,
You have a $5 million property.
yep.
There's no tax on that gain.
But the
$5 million goes to the full 5 million goes to work.
hmm
Okay, and buy
so I'll get a credit
a
for
portfolio.
years after doing that.
Correct. You'll get a check. Yes,
I'll get a
and
check.
not just annually. You can do it monthly or quarterly. Most
Great.
people get paid quarterly, but that's for the rest of your life, or the rest of your life and your surviving spouse's life. If you're already over 70, I would say set it up for a term of years.
Mm-hmm.
You can do up to 20. And then even if you die within that 20 years, your
It
children
goes into your children.
will keep getting it. When the term is up, or when you and your spouse pass, you've been getting this money from the
Yeah.
child, then it goes to the charities you've named. You
Wonderful.
can name one charity, you can name 50 charities.
I know a lot of successful high net worth individuals do leave a lot to charity, and that must be what it's for. That must be
Yes.
just so that while they're alive, they can get a lot of tax breaks. And then also, their children, those that inherit the properties, the assets in the trust also get some tax breaks.
Correct.
That makes sense. One of the questions I wanted to ask you plays with that too is how do the wealthy stay wealthy? And it sounds like aside from, keeping it in the family, how
Well,
is
one
the
thing
trust or
with it, when the property then or the proceeds, let's say it's a portfolio of stocks that have been
yeah,
purchased with the proceeds of the real estate sale. When
or
those,
any sale,
when
right?
those
Does it
go,
have to be real estate?
no,
No.
any,
Yes.
could,
So just the assets of it.
could be a business.
Yes. And that was one of the things we're going to go
Socially held bill.
Yeah.
But once those assets then go to the remainder beneficiary,
Yeah.
which is the charity,
Yeah.
um, the children can receive life insurance. So very often, at the same time I'm setting up a CRT, I set up an ILATE,
Mm.
an acronym for irrevocable life insurance trust. Okay. And we use some of the tax savings to fund the premiums to for the policy that's going to go into the life insurance trust, which pays out to the kids at the same time that the CRT money is going to the charity.
So the taxes they would have on that in that insurance,
There's no tax on
there's
it
no taxes because
because it's in the IRA.
got it.
And that's a
So that is something interesting.
people think there were no taxes on insurance. Well, there's no income tax on an insurance death benefit to the beneficiary.
Yeah.
But insurance policies, if they're owned by the insured, there most certainly is an estate tax if their estate is large enough to trigger an estate tax.
And that is due while they are alive, or what?
Well,
So
yes, the
so if I'm leaving my
IRA is
paycheck-
set up at the same time as the CRT
got
to
it.
be in fact, we call it a wealth replacement trust. We call it a wealth replacement trust because wealth is at the trust maker's death,
Mm-hmm.
wealth is going to the charities, right?
Mm-hmm.
And so the kids, so they don't feel disinherited, will be getting an insurance payout.
I love that you mentioned this because everybody nowadays is very big on the wealthy and how they're keeping their wealth and growing their wealth. So you're saying the CRT in lieu or along with the life insurance policy being set up for the kids.
Well, the very wealthy, we will set up a dynasty trust for. A dynasty just means multi-generational.
Great.
So there's no estate tax paid at each generation. We can't do that under California law. California is not as friendly.
Yeah,
We do that under South Dakota or Nevada.
got it. I know that you're also licensed in other states, so it's
I'm
interesting.
licensed in Florida and New York.
Yeah.
And then for setting up a dynasty trust, and I would work with this. I do the initial drafting, and I have a licensed attorney in those states bless the documents, make
Wonderful.
sure it conforms with those states' laws. Good thing about South Dakota is that they've abolished something called the rule against perpetuities, which I know is very legalistic. But it just means
that means forever.
yeah,
Yeah.
the trust can stay in force forever like a corporation can.
Mm-hmm.
Whereas in California, 90 years is the max.
Yeah.
Um,
Well, let's tone it down. Let's bring it back to some subjects that I want to make sure we cover.
sure.
As a mom, I am most curious and most nervous about what happens to me when I die for my children. And I know that quite a few of my clients are. Now, I don't know if it'll happen to me. My kids are too young, but I have seen where a couple of clients of mine have multiple properties and have a child that never had to fend for themselves, that they've kind of babied all the way up until their 50s, 60s, and now they're just worried what happens when I die. And my kid that doesn't know how to live on his own or isn't capable of living.
That's why we set up the trust so
Yeah.
that there's not an immediate payout upon your death.
Mm-hmm.
The trustee, and this is why I like corporate fiduciaries, trust companies, or private professional fiduciaries
Yeah.
who know what they're doing, do not go on vacation, they don't die,
Yeah.
and they follow the letter of the trust.
Yeah.
And that trustee, that professional trustee, will dole out money for the kids. And at certain ages, the children are allowed to withdraw. It's not a forced distribution, but it's a permissive withdrawal at certain ages by the children.
That's how you can protect from your kid just taking all the money and splat
Not just
like using it all.
not just
Yeah.
protecting against their buying a Ferrari,
Yeah.
but protecting against judgments against them.
Mm-hmm.
And most importantly,
Yeah.
protecting against bad marriages.
Yeah. Ooh.
Because
Inheritance are not part of
well, once
co-owned.
Right.
Like,
Once the child gets their inheritance,
Yeah.
let's say they get an outright
that's
distribution,
excluded from marital assets. Yeah.
they can do well. They can
They can take them
someone's for property until they add it to their
until they pull the money and put it in their Bank of America or their joint bank account.
yeah. And even if it's sold as separate property, if they don't have any estate planning of their own, their spouse is going to get a piece of that,
I see.
maybe a large piece of it. depending on it.
Maybe half of it, right?
But even so, what will usually happen is when they inherit something early, they'll just add it to a joint account with they'll use it to buy property in joint names.
Yes.
So their spouse that has the money. Then a divorce happens. So then that spouse, well, let's take the best case. the most egregious case, your your child who's inherited money from you, maybe a lot of money, then passes away, has no estate planning of their own, and there are no children. Everything is going to go to that spouse.
Hmm.
And then the spouse marries someone else. Your money has now gone to a stranger.
I see.
Most people don't want that.
No,
No,
I mean,
that's fine. I don't
yeah,
want that.
I would
Well,
not want
most people
that.
don't want it.
Yeah, I would not want that.
So we set it up ideally so that the trust will, even if it's not a dynasty trust, but we set it up the trust to last at least more than one generation, and the children at certain ages will have a right to withdraw some principal. Now, what if long before then they need money for school? The trustee can dole out
Because
money for that.
you're talking about in the trust, you can categorize these costs
Sure.
almost, right?
And medical
Yeah.
expenses, money for a first home, down
Yeah.
payment
Yeah.
to start a
Now, I
big
hear that you could also direct in your trust, like no money's released until they graduate college or until they have their first child or until they hit
yeah,
different
we
milestones.
could put
Yeah.
incentive
Yeah.
provisions in there.
Got it.
Um, the more specific it is, if there's going to be an incentive,
Hmm.
the probably the better because if it ever has to go to court for court determination on a incentive provision, courts don't want to be in that position. They only want
Yeah.
something that's very black and white in there.
They want
So
to just direct. They want to
that's
just say
why
okay to what you
putting ages,
Yeah.
where there's no right of withdrawal until the age of 35,
Got it.
and then 20%. Then it's
But I just want to say that the 20s were rough for me, they were rough. And then I started growing up
you
and
don't allow withdrawals in the 20 in the trust that I do for that reason, unless the client specifically wants
yeah.
that. They're the
I hope
boss.
that more parents will at least give a little something in their 20s. Not the entirely, not maybe not even a large portion, but the 20s are so rough.
If a
But
child inherits money and then is in an auto accident where they're in fault, and
yeah.
there's a judgment against them
Yes.
for well above policy limits, your money now is going towards paying a judgment debtor,
Mm,
a judgment creditor.
got it.
I'm
Got
sorry,
it. Okay.
of
So
your
there are
child.
provisions like that. And
Oh, yes. Well, that's why we want to keep it in the trust because it's
yeah.
protected.
Now we talked about having a successor, naming one. I have 5 children and I have a good idea of who I would name my successor. Now, what happens if,
But you don't have to name any of the children, especially
you
if
can name someone else outside of my kids? Yeah.
yes, but I would say name a trust company
Oh, got it.
or
Yeah.
name a firm which is a bonded, licensed PPF, private professional fiduciary.
That might actually be better. One of my friends right now, um,
Well, the first thing that people will ask me, what's it going to cost?
mhm.
Well, first of all, they don't start charging until after you're dead. But whether it's one and a quarter, I say it's worth every penny if it keeps your estate out of litigation.
Yes, and litigation.
That's where it gets expensive, not the cost of the private.
Would you say that the number one reason you handle litigation is between siblings?
Between siblings who are alleging financial elder abuse against one of the that they're
Wow,
supposed
so
to.
that's common. I hear that quite a lot, but you're saying
Oh,
that
yes, that's a
that's
litigate the
typical.
most.
Yeah.
Yes, because that can get
Or having them change it while they're
there can be enormous
incapacitated.
damage awards by statute in financial elder abuse cases, or they're alleging that one of their siblings
Had forced the hand to change the
well
trust.
exercised undue influence over mommy dearest, or coerced her, or because they were that's where a child was living with the now deceased parent and providing services.
Yes, yes, yes.
And so there's a lot of room for excessive persuasion, as the
That
statute uses that term.
I would
Excessive
the term guilt writing, I mean, and I see that actually just to hit a topic that's a conversation I'm having with one of my friends. Um, you know, Father passed away, 4 kids, 2 of them out of the country. They're coming out of the woodworks. They had all balance and equal amounts in the trust. And then, father got sick. Father, one of the siblings came out and was more active versus the prior years. So then
That case is going to be litigated.
yes, it's in litigation.
Special,
Yes.
yeah. And that's where we lawyers really make a lot more money than in the draft. So if you want to
Now, do you make
Ki-
more money dragging it out, or is it just
I
kind
don't
of
drag it out, but when there are legitimate fights, I'm
yeah?
not going to surrender here.
Okay. Did you hear that, everybody? Keith is not going to surrender. No.
And the case that
But do you sometimes just try to surrender to like not in a bad way,
what
but
the
just
other
get it over
side,
with?
what the other side is offering.
Yeah.
If it's
What's your longest litigation?
well, it started in 2019 and ended in 2024.
Wow, you must
5 years, and the trial itself was 6 weeks, which was the longest trial that the judge who presided over it ever had. And he then retired. It was so long.
So not
How did
only
that-
are you losing time, which is valuable, but you're not losing, but you're paying a lot to attorneys.
Yes, the attorney fees were well over $1 million.
Wow.
Well,
And so
I
that
can-
eats into that eats into, of course, the assets that you're gonna get. So is there mediation? Is there mediation
Yes,
before
mediation is voluntary.
Mm-hmm.
You don't have to. It's not like arbitration where there can be a binding. With mediation, which is expensive,
Yeah.
$6,000 to $8,000 for a day.
Hmm.
And
Do you handle that too?
yeah, I do the mediation.
Yeah.
No, I'm not the mediator.
No.
No,
No,
but
you're
is that-
present with
but
your client, then they're
So you have
present with their
attorney's
client.
fees for being there all day, and the mediator charges a fortune. Those are retired judges usually.
Yeah, right.
Um, and
Well, is it cheap?
and at the end of the day, it is not binding.
Okay, I see. So you could still walk away after that whole day of
And
getting all of that.
more often than not, that's what happens.
So they walk away not sad.
Unless one side knows they have a very weak case. But usually pride gets in the way, emotions get in the way.
It's even on the real estate side when I handle probate or estate sales, it's kind of crazy how everyone could get along until it's time to disperse the net, the net proceeds. And then it's dispersed individually. So if I have more taxes due than my sister, then I just start getting jealous, even though
Well,
it's still my fault that I owe my
I said
taxes.
the fights start while the decedent is still
Alive.
alive.
Mm,
We say, well, the body's still warm.
yeah.
The fights will continue until
Are you getting
some
contacted
resolution.
a lot right before they die?
I get contacted when there's been a change after a trust has been enforced, let's say but revocable, let's say for 20 years,
Yeah.
and then the decedent who is then like in their 80s makes a radical change from what existed. That's when you get called.
Got it. Got
Yeah.
it. And do you, as a lawyer, ever say, hey, Joe, it's been 20, 25 years, man. Are you sure you're okay to change this? Like, do you ever notice?
If someone, well, I will ask them various questions
So you have
to see, and if I'm not satisfied, I will send that person to a neuropsychologist
to get
to make
confidence.
sure that they meet the definition of mental competency under our probate code.
Got it. So that's your ethics and code right there for
Yeah.
handling big changes like that.
But I'll ask them some basic questions
Now, I'm
first.
going to throw this out there. My dad, depending on who he likes the most, and I love you, Dad, but depending on who he likes the most, sometimes he'll make changes to his trust quite often.
As long as he is mentally competent, he can change it every day, and no one is
You've been known to.
whispering in his ear. As long as no one is putting any kind of pressure on him,
Yeah.
or persuasion, and he is fully competent, he can change his trust or will every day.
Okay.
The only limitations on that are our community property laws. But if your dad is now a widower, he can change it.
No, my
Oh.
dad's very well married. He's been
Oh.
married for a long time now.
Okay, so if he disinherited your mom, she would have a claim, notwithstanding what the trusted will says. But children do not have a right to inherit. They don't have a right to inherit if their parent chooses to disinherit them.
Yeah.
Disinherit.
Does that matter if they're married or not? Like, could my
No.
dad disinherit someone? But
But if someone doesn't have an estate plan and they
Yeah.
have children,
they're all
those children cannot be disinherited.
yeah.
Because that's why I say that the state will make your estate plan for you if you don't have anything,
yeah,
and you may not like it.
yeah.
Okay. But before, and I was going to say that if there's a piece of real estate in the trust or the probate estate, and there is we'll call it devise bequest of a piece of real estate to 5 children, let's say, okay, how are those 5 children going to take And the trustee, the personal representative of the estate, is not going to sell the property because he knows that dad or mom wanted that piece of property to stay in the family. Well, now you have 5 kids, say, taking that single piece of property, each has tenant in common.
Yeah.
Well, one tenant in common
What's
can,
the sense? Yeah.
or not just that. Let's say one tenant in common dies. That 20% piece of the whole, because they don't own the whole fee simple. They don't own the whole hunt.
Yeah.
That goes according to, they may have 5 kids.
Yeah.
All right, now
Yeah.
you've got
So
5 and 4. Now you got 9 tenants in common. And you see how that can,
yes, yes.
you could have a
The
whole,
more, oh, the more people, it's just crazy. So I
what? How does that? If one tenant in common, one child gets into that auto accident I was talking about,
yeah.
and is sued and loses, well, now you could have a judgment creditor put a lien on the whole property.
Wow.
And while the other children can, it won't be against their share, the property can still be sold out from under them.
Mhm.
So it's just,
There's so many things to it. We definitely need a follow up to this. I know we're coming up to our 15 minutes already, so I want to make sure that we say whatever we want to say.
what people need to do is think about, and this is when you
Yeah.
need a lawyer,
Yeah.
and
not just go on the
not just some service.
yes, yes,
I won't mention brand names, but
yeah,
you need to have someone who's experienced, who has seen what happens on the other side of death, say, well, what if this happened? What if that happened? Have you thought? And so often I get the client said, I never thought of that.
I want you to tell us at the end how somebody could do a consult, what that looks like. But before that, I just wanted real quick for people that have disabled or autistic children,
Special needs
yeah,
trust.
special needs trust. I want to make sure that that's said. And then also for children that are taking care of parents and don't have family around, you have the elder law that protects them. You would handle that in the trust as well.
Well,
Right.
I can put a whole, we call it an article,
Yeah.
a whole series of provisions regarding special needs
Yes.
into a revocable trust, or
That protects their
I
care.
prefer to do a standalone
Yeah.
because then it makes the trust document so long and unwieldy. I do standalone special needs. This is third party. Third party means that the person with the special needs is not the one who set it up.
Yeah.
So it's a third party
So
special needs.
dad sets it up for their disabled or mentally
And what is the purpose of that? To make sure that the special needs child does not lose any government benefits by virtue of their inheritance from this trust. That's what it's about. It's a form of asset protection, especially for kids on the autism spectrum,
Yeah.
so that the government will not uh, treat them as wealthy people and lower their benefits.
I think that's super important because you would imagine that if you have a lot of money, you have an autistic child to use as an example, you leave them their inheritance. What you're saying is the trust. There's a way for you to write the standalone trust to protect them from the government saying, "Hey, you don't need our Medicaid, you don't need our assistance.
Right.
You can use your money, and then it runs out."
Right.
So
And we could set that up with $100 in a checking account just to get the trust.
yeah,
And then money pours over from the main trust
yeah.
to that special needs trust at the time of death.
I see. I see. Thank you so much, Keith. If somebody wanted to reach out to just talk a little bit more about their specific need or question,
My phone number is not 949-622-5450. That's 949-622-5450. Website, octrustlawyer.com. OC like Orange County, trust lawyer altogether.com.
and set up that consultation because it does vary. Pricing varies,
Price,
situation
yeah.
varies, what kind of trust it would vary.
right.
But we did unpack a lot today, and I really want to thank you, Keith. We'll probably follow this up because there's so much more to dive into.
Okay.
But let's see what kind of questions we get, and we'll reach out to anybody that does have questions, and we'll get, either you or myself. We'll start answering their questions and inquiries.
Very good.
Yeah.
Okay.
All right. Thank you. So we unpacked so much today. I know that we went through a lot of jargon, a lot of verbiage, and a lot of scenarios. If you have any questions, we do plan to have a follow-up session on this with Keith himself again. So please leave a comment, email, write us, even call or text with those questions, and we'll make sure that they're included in the next segment coming up. Thank you, everyone.
Thank you.
Talk to you all soon.
Talk soon.
Stay protected.